Looking at the list of Trump's businesses that have failed and his hotels that have gone bankrupt makes you wonder what exactly he does that he's good at, doesn't it? ProPublica broke a story in 2018 that could explain it. Money laundering and fraud. And the blueprint could be the Trump Ocean Club in Panama, where he made up to $55 million while the club itself and his partners went bankrupt. They broke ground in 2007. Construction funded by a $220 million bond underwritten by Trump's longtime bank, Bear Stearns, and backed by pre-sale contracts, where people bought condos at the club before it opened by depositing 30% and promising to pay the rest when it opened. But when the Trump Ocean Club actually opened in 2011, over half the pre-sale contracts were abandoned, along with $50 million in deposits paid for them. Why would so many buyers give up so much money?
Maybe because they were buying pre-sale contracts, not condos. A drug dealer forms a Panamanian shell corporation that uses dirty money as deposit on pre-sale contracts, then sells the corporation. Rinse and repeat as long as there's interest in the club, which Trump did his part to keep up, mostly through fraud. Said he had his own money invested in it when he didn't. Said condos were nearly sold out when they weren't. And even went so far as to promise some investors guaranteed returns. According to the story, Panama was just the first international Trump-branded resort to go bankrupt while he made millions. So if the story turns out to be true, Trump committed a lot of crimes, many from Trump Tower in Manhattan. What's the New York County DA supposed to do with the story? Ignore it? New York prosecutors took the case to an investigative grand jury, which subpoenaed Trump's longtime accounting firm Mazars for his personal business records. Trump sued in federal district court to stop Mazars from responding. Lost. Appealed to the circuit court. Lost again. Appealed to the Supreme Court. And lost yet again.
The court rejected two arguments. The first one was unanimous. Trump argued for absolute immunity from state criminal subpoenas during a president's term, which would mean if the president had a picture of his friend robbing a liquor store, state prosecutors couldn't subpoena it until he's out of office, even if the statute of limitations runs in the interim so the guy gets away with it. And despite the fact that if it had been a bank instead of a liquor store, it would have been a federal crime, and federal prosecutors have been able to subpoena the president for evidence in criminal cases since Chief Justice John Marshall made President Thomas Jefferson respond to a subpoena in the treason case against Aaron Burr, the guy who killed Alexander Hamilton in a duel. So since always. Notwithstanding all that, Trump said responding to state criminal subpoenas would distract from his overwhelming presidential responsibilities. And without immunity, 2,300 prosecutors could be weaponized to harass the president with subpoenas.
The Supreme Court rejected Trump's absolute immunity argument for the same reasons why it rejected Clinton's nearly identical argument when Paula Jones sued him for sexual misconduct. Of course, getting sued would weigh heavy on anyone's mind, but the court allowed the lawsuit to continue because it didn't distract from Clinton's official presidential decisions. And neither does a third-party subpoena for Trump's personal business records. And while allowing Paula Jones, a private citizen, to sue the president risked tens of thousands of private lawsuits just to harass. If the risk were ever realized, federal courts would protect the president by stopping those cases, or cases brought in bad faith, or those that actually interfered with presidential duties. Similarly, federal courts would also protect Trump and future presidents against weaponized prosecutors.
While the Supreme Court unanimously rejected Trump's absolute immunity argument, it split on his second. To subpoena the president, state prosecutors should have to go to federal court first and prove the requested information is 1. Critical to a charging decision, 2. Not available anywhere else, and 3. Needed immediately. The argument is based on U.S. v. Nixon, where a special prosecutor subpoenaed tape recordings of Oval Office meetings from then-President Richard Nixon, who objected on the grounds that the tapes were privileged presidential communications. The president needs to speak freely with those who inform official decisions, but they would hold back if what they talked about were made public. It'd be like the whole country eavesdropping on every conversation. So those communications are privileged and ordinarily protected from disclosure. But the Supreme Court said in Nixon that the president cannot withhold privileged documents if prosecutors demonstrate a specific need for the evidence in a criminal trial.
New York County Grand Jury did not subpoena President Trump for privileged documents. It subpoenaed an accounting firm for personal documents related to Donald Trump, the individual, for a time period predating his presidency. Chief Justice John Roberts, joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan, refused to apply the standard set to overcome presidential privilege. to personal documents that have nothing to do with running the country. So, as long as a subpoena for non-privileged documents is issued in good faith and doesn't actually interfere with the president's official responsibilities, there's no reason why state prosecutors should have to meet a higher standard than federal prosecutors.
A higher standard would mean the grand jury wouldn't get all information that might possibly bear on its investigation, which is what it's entitled to. And waiting out the presidency doesn't work because even if the evidence is properly preserved, in the meantime, prosecutors would be deprived of leads, which would make it harder to identify, investigate, and indict third parties. Witnesses' memories fade. Documents get lost. Statute of limitations could run. Best case, guilty gets away with it. Worst case, innocent ends up in prison.
After deciding against both absolute immunity and a higher standard to subpoena the president, the Supreme Court remanded the case back to district court, where Trump can challenge the subpoena just like anyone else. Because in America, no citizen, not even the president, is categorically above the common law duty to produce evidence when called upon in a criminal proceeding.
Justice Kavanaugh is joined by Justice Gorsuch in what they call a concurrence to make it seem like a 7-2 decision, but in substance they dissent. They concur the case should go back to district court, but they would have prosecutors meet the higher standard to enforce a subpoena. And they get to that conclusion by reframing the Nixon decision to apply a higher standard, not to overcome presidential privilege, but to balance presidential duties with criminal investigations. And since this case also pits presidential duties against a criminal investigation, the same standard should apply. But here's the Nixon case. Here are the pages discussing and analyzing presidential privilege, its history, how and why it applies. Here are the pages balancing presidential duties with criminal investigations. And this is the Supreme Court's conclusion. Nixon is about privilege.
Justice Thomas dissented by himself with an interesting take on the case. State prosecutors can subpoena the president's personal documents, but if the president says official duties demand his or her whole time, the court has to take it at face value and cannot enforce the subpoena. So while not immune from getting subpoenaed, effectively immune from having to respond.
Justice Alito, also dissenting by himself, would have prosecutors meet the higher standard to subpoena their president regardless of privilege. He can't seem to believe the president is not above the law. For all practical purposes, the court's decision places a president in the same unenviable position as any other person whose records are subpoenaed by a grand jury.
And that ends the 4-part series on grand juries. We really hope you learned something. Please like and subscribe if you did, and be on the lookout for future videos on more legal topics.